Section 1, Introduction. Introduction of characters. I'm Jean Libor and I'll be playing employee, Dr. Chen.
I'm James, and I'll be the narrator and mediator.
I'm Hoi Tong Lee. I'm the HR manager.
I'm Harish Kumar. I'm the union rep.
I'm Andreas, and I'll be playing the employer representative.
Hello, everyone. This roleplay scenario will be set within the dispute between the Australian University Monash and Dr. Chen, who is a part of the staff at Monash. The parties involved in this dispute will include the employee representatives, HR manager, union representative, mediator, and Dr. Chen, who is a victim in this dispute. The purpose of this roleplay is to create a constructive simulation of how the proceedings of the negotiation would have gone down concerning Dr. Chen's situation, which he has had with sexual harassment, inappropriate conduct, power imbalance, and sexual discrimination in promotion decisions. The alleged incidents occurred approximately in the period between 2010 and 2012. In May 28th of 2013, a settlement was offered to Dr. Chen by Monash University. However, this was rejected by Dr. Chen despite potential financial consequences during 2014. During 2014, a 15-day trial was conducted where extensive arguments and evidence was provided for both parties. The trial concluded in 2015 with Justice Tracy finding for Monash University that the allegations were unsubstantiated. Subsequent negotiations between Monash University and Dr. Chen followed the court's findings. This roleplay will closely follow the events outlined in the Federal Court of Australia, Chen v Monash University, 2015 FCA 130, and the article published by The Age in 2015 called Monash University awarded $900,000 in indemnity costs for failed sexual harassment case. We'll use the written judicial decision document and article for the purpose of recreating a negotiation of the dispute and finding a resolution. The dispute begins with the issue arising in the University of Monash located in Victoria, Australia, where Dr. Chen, who is a staff member at the university, has claimed to be subject to many accounts of sexual discrimination, misconduct, and discriminatory views with promotion outcomes. These allegations have been made over the years rather than being a one-off event.
During my time at Monash University, I have observed a recurring pattern of discriminatory behaviour that I believe is inappropriate and unacceptable. This has included social interactions and comments that have made me feel uncomfortable and cross professional boundaries within our workplace. Initially, I did raise a formal complaint due to concerns about the power imbalance involved and the potential impact this would have on my career. However, over time, particularly when promotion opportunities arose, I believe this discrimination influenced how my research and my performance were perceived and assessed. I feel that it negatively affected the decision-making regarding my advancement, which I consider to both be unfair and dishonest.
From the union's perspective on this matter, this raises a serious concern for the procedural fairness with the promotions and a breach of Sex Discrimination Act 1984. Furthermore, under the Sex Discrimination Act 1984, Article 28A and 28B, which state that harassment may come from unwanted conduct in sexual manner, where this misconduct may make a person feel humiliated, intimidated, or offended. Importantly, this also means the time between it happening and now does not negate the misconduct. Lastly, discrimination cannot affect employees' promotion, especially sexual discrimination.
The university acknowledged the allegations to the highest degree, as sexual misconduct is not welcome at the university and it is a serious issue. However, I will clarify that the university has policy relating to fair treatment, promotion, and complaint handling. This situation has raised questions about how our policy have been put in place and if they have been applied effectively among our employees. The HR role today is to ensure process integrity and to keep consistency with legislation and policies.
The university bases promotion decisions on academic performance, performance metrics, and institutional metrics. However, we also recognize that workplace interpersonal conduct can affect the promotion decision-making phase. The faculty takes workplace harassment very seriously and recognizes the Sex Discrimination Act of 1984 when enforcing policies. We, as Monash, understand that we are liable for any misconduct against Mrs. Chen.
Everyone understands that if this is not resolved early, it could escalate into formal complaints or litigation, which is costly and uncertain for all involved. The parties now set some ground rules and clearly explain their positions. Let's agree to speak respectfully, avoid interruptions, and focus on solutions rather than blame.
I'm not here to accuse anyone. I want acknowledgement of the impact this has had on me and reassurance that things will improve.
While we don't accept wrongdoing, we're willing to look at constructive ways forward.
We will identify concerns, expectations, and support a solution that strengthens trust in our processes.
And one that includes real measurable commitments.
The bargaining stage focuses on problem solving and finding options that meet everyone's interests.
One option is an independent review of promotion decision and criteria to make sure they're applied consistently and without bias.
That's something we could consider. An external review could help improve transparency.
I'd also benefit from clearer feedback and mentoring so I know exactly what's expected for future promotion rounds.
We can put a formal mentoring arrangement in place and standardize promotion feedback and also provide mandatory harassment prevention training for senior staff.
What about prevention going forward?
Mandatory training on harassment and appropriate workplace behavior for senior staff.
And ongoing monitoring, not just a one-off section.
That sounds reasonable, provided timelines are clear.
The parties will now summarize what they've agreed on. So we are agreeing to an independent promotion review, staff training, mentor and support for Dr. Chen, a written acknowledgement of impact and regular follow-ups.
That addresses my concerns and helps me move forward.
These commitments are specific, which is important.
These commitments are measurable, specific, and aligned with the legal and policy standards. HR can manage implementation and reporting.
This approach is fair and constructive.
The final stage focuses on making sure the agreement actually happens.
We will provide written progress reports and establish a specific point for context for any updates every 6 months.
The union will stay involved to ensure follow-through.
Knowing there's a clear process gives me reassurance.
This helps avoid further dispute and supports a healthier workplace.
The agreement allows both sides to resolve the issue early, protect legal rights, and avoid the financial and emotional costs that often come with prolonged litigation. This outcome acknowledges concerns, improves systems, and allows everyone to move forward.
I feel heard.
It shows the value of early resolution.
And it strengthens our processes and also reflect a balanced, legally responsible, constructive outcome for all parties.
We can now focus on the future.